Good morning, everyone. Welcome to the Devry Smith and Frank HR Employment Seminar. For those of you who've been with us before, I will skip over the rules quickly, but for those of you who have not, we're going to try to push through each of the topics today in our usual format, and we will ensure that we get you in and out as quickly as we can. So we ask everyone to hold their questions. If you have online questions, feel free to send them in. We will be answering those after the seminar concludes. But we're going to go one by one and have each of us come up and introduce the other and get through the topics quickly so that everyone can get on with their busy day. We have some materials that are available for those here and also for those online. So we've got a number of speakers today and some interesting topics and some first-time speakers, so that's good. Welcome, Eric. We'll jump right in. My name is Larry. I'm the managing partner of the firm. I'm going to be doing the topic of the 24-month notice cap and the case of Dawe versus Equitable Life Insurance Company of Canada. So jumping right in, we're going to talk about the Superior Court decision, and we're also then going to talk about the Court of Appeals decision, and we'll talk about some takeaways for everyone as a result of the two decisions that have come down. So starting with the Superior Court decision, so Mr. Michael Dawe was a vice president of Equitable Life Insurance Company. He was hired in 1978, and he worked with the company and its predecessor, Allstate, for 37 years. He had several promotions over the years, and in the end of his career, he was earning a salary of $249,000 as a base. He also earned a significant bonus of $379,000 in 2015. So he had a significant salary compensation arrangement. He was terminated on October the 8th, 2015, without cause, and he was 62 at the time of the termination. So why was he terminated? In September, Mr. Dawe had a minor disagreement regarding some sporting tickets and the purchase of those to entertain clients. There seemed to be a bit of a personality conflict with the president, Mr. Beatam. Mr. Beatam reprimanded Mr. Dawe, and the dispute sort of escalated. Mr. Dawe complained to management. He then retained a lawyer, and he attempted unsuccessfully to negotiate an exit strategy from the company. Instead, the board of directors decided to terminate Mr. Dawe in October, and upon termination, Mr. Dawe had been rejecting an offer from the company of 24 months notice. So it all sort of escalated fairly quickly. So the main issue, obviously, before the Superior Court was what was the appropriate notice period. Mr. Dawe had sought a 30-month notice period. Equitable Life had argued that it should be 24. The Superior Court agreed with Mr. Dawe and awarded him the 30-month notice, and we're going to get into why. So just taking a step back, obviously, for those of you who've been here for the first time, Bardol is a very well-known case, and it's the seminal case in terms of how to determine reasonable notice at common law. One looks at applicable factors, including some of the ones I've listed here: age, character of the employment, length of service, and the availability of similar employment, having regard to the qualifications of the employee. So that's generally what the court's trying to assess, is what is the reasonable notice period for someone in Mr. Dawe's situation, relying on the Bardol factors. There's a large line of case law that says that 24 months is the maximum notice period in most cases. And there's been some competing case law over the most recent years about this, and there was some suggestion that it wasn't a cap, and then it has sort of reverted back. And so we got some instruction here, both from this court and as well as the previous Court of Appeal decision in 2006, Lowndes versus Summit Ford Sales Limited. And the court in Lowndes said that although it's true that reasonable notice of employment termination must be determined on a specific case-by-case basis, there's no absolute upper limit or cap on what constitutes reasonable notice. Generally, though, only exceptional circumstances will support a base notice period in excess of 24 months. So the Court of Appeal in 2006 was saying it's a case-by-case analysis, but generally it's a 24-month top or cap. The Court of Appeal also was saying in 2016 that reasonable notice is often referred to as a period of time it should be reasonably taken to a terminated employee to find comparable work. So in that sort of an analysis, a cap wouldn't make any sense because it may very well take longer than 24 months. So that's sort of the background case law that the Superior Court was looking at. So the court applied that law to Mr. Dawe's case and held that since Mr. Dawe was a senior vice president and he was a senior management member, and there were no similar employment opportunities, his mitigation efforts demonstrated that there was a significant lack of opportunity available for him given his age and years of service. And Mr. Dawe had made no decision to retire, and he had in fact said he was committed to continuing working to at least the age of 65. So in that scenario, the court held that this termination was tantamount in effect to a forced retirement because given his age of 62, he was essentially forced to retire before the age of 65 and had well planned to continue working beyond 65. The court held that Mr. Dawe was at the extreme high end of the Bartle factors, which I think is true, and he should have been allowed to retire on his own terms. And with no comparable employment opportunities in particular, the court felt that the case warranted a minimum of 36 months of notice. But since Mr. Dawe had only asked for 30, the court ultimately decided that 30 months was more than reasonable. The court felt that this was an exceptional circumstance, recognizing the change in society's attitudes towards retirement, and in particular, the circumstances that the former employee must consider. For many years, the usual retirement was age 65, but mandatory retirement had been abolished in 2006, and so those presumptive standards no longer applied in the court's view. So, the court decided that 30 months was enough and was appropriate, and that would in effect get him to his 65, and as a result of that analysis, determined that this was an exceptional case. The Court of Appeal decision came along, Equitable Life Appeal. The motion judge's determination of reasonable notice was held to be excessive. And so the court found that the analysis that the lower court went through was not an appropriate analysis, and they found that the 30-month notice period was too much, and instead reduced the notice period to 24 months. The court held that there was no exceptional circumstances that warranted a longer notice period, and although Mr. Dawe had substantial circumstances, they were not exceptional. His years of service, etc., age, and his difficulty finding new employment warranted a substantial notice period. However, there was no basis to award him more than the 24 months. Why? Why did the court say that? Well, the court went back and looked at the Lowndes decision and went through the analysis of the lower court and said that this was the appropriate analysis, and this is the appropriate standard by which to apply. It's a case specific, there's no absolute limit, and only in exceptional circumstances will a basic notice period in excess of 24 months be awarded. So the court said this is the approach that the Lowndes case in 2006 had set down, and this is the approach that the lower courts should follow. The court also said that Lowndes had been followed many times since then, and the court referred to the Keenan and Canak Kitchens case in 2016. And in that case, a 26-month notice period was awarded to a husband and wife with exceptional circumstances. And in that case, the husband and wife were 63 and 61 respectively, and they had extremely lengthy notice periods of 32 years and 25 years, and the court held that 26 months in that case would fly. The court also looked at Strudwick and applied consumer clinical evaluations, which is, again, a 2016 Court of Appeal decision, and effectively supported the Lowndes analysis, case by case and exceptional circumstances for 24 months. In the Strudwick case, they refused to increase the notice period beyond 20. So the Court of Appeal applied this law to Mr. Dawe and indicated that the motions judge approach was an error, that there were no exceptional circumstances in this case, and the motion judge took a different approach than was established by the law. And in particular, the Court of Appeal did not like the motions judge attempt to talk about broader social factors, and did not like his conclusion that the presumptive standards were inapplicable. The motion judge had stated what I read to you earlier about the mandatory retirement and its abolishment, and it's important to recognize that case is unique and that the presumptive standards didn't apply. The Court of Appeal really didn't like that part of the decision. The Court of Appeal felt it was an error for the judge to go beyond sort of the case law analysis and to start looking at social norms and to try to sort of put his own impressions of social norms onto the case law. So instead of relying on his own perceptions of the change in society's attitudes regarding retirement, the motions judge should have followed Lowndes. Changes in mandatory retirement laws were known at the time of the Lowndes decision. Recent cases which have been decided after the mandatory retirement legislation had changed had not altered the approach in Lowndes, and Mr. Dawe's circumstances were similar to those in Lowndes, in which there was a 59-year employee who had worked for 28 years, held a management position, etc. So that was the first ground that the court did not like. Secondly, the Court of Appeal said that Mr. Dawe's retirement plans ought not to be determinative, and that's something that the lower court had relied on. And the Court of Appeal relied on the Strudwick decision, which stands for the proposition that absent a fixed-term contract, an employer does not guarantee an employment to retirement. So the fact that Mr. Dawe was 62 and he'd hoped to continue working beyond 65 does not necessarily entitle him to do so, and it certainly does not entitle him to a 3-year notice period or a 4-year notice period to get him beyond the age 65. And the court referenced the quote, "In entering in the employment relationship, an employer cannot reasonably be seen as having accepted the risk that in a dismissal of an employee, it would be obliged to pay an employee until their retirement." So the court effectively is saying it doesn't matter what the employee's intentions are in respect of retirement. That is not a relevant consideration for the court, and the lower court judge erred when he relied on that. The third ground that the Court of Appeal took exception with was the motion judge viewing the case as being tantamount to forced retirement. The court said no, and that in fact what happened here was Mr. Dawe had requested an exit strategy, and so at some level the court took exception to the fact that Mr. Dawe retained a lawyer, had tried to sort of negotiate something, and had in effect rejected a 24-month notice period. So he himself acknowledged that he was perhaps prepared to leave, and so the court took exception to the motion judge determining that the termination was tantamount to forcing him to retire. So those were the three grounds that the Court of Appeal did not like that the motion judge relied on. The Court of Appeal did agree that the motions judge was correct in determining that Mr. Dawe's circumstances warranted a substantial notice period, and decided that the 24 months was the upper end was applicable to Mr. Dawe, but there was no basis, they said, to go beyond the 24 months and go to 30 months. That's the decision of the Court of Appeal. I'm not sure I agree, to be honest. Not that anybody asked me, but in the Lowndes decision, they had very similar notice and service periods to Mr. Dawe, and they determined in that case that it was exceptional. So I'm not sure what one has to do as an employee in order to qualify for what an exceptional circumstance. I would have thought that exceptional is working somewhere for 35 years. That seems like an exception to me. And it may be easy for some of us, or even some of the people younger than me, to sort of skip over, but I just did a quick Google search while I was looking. Mr. Dawe started there in 1978. In 1978, that's Pierre Trudeau and Jimmy Carter as the relevant chief officials. Our current Prime Minister was only 6 years old at the time, and Andrew Scheer hadn't even been born, our opposition leader. So that's a long, long time, and 35 years might roll off the tongue pretty quickly, but that's a long, long time. And maybe just for some of the younger people in the audience, 8 tracks, Space Invaders, Saturday Night Fever, that's all came out in 1978. So that is exceptional in my view, and that would have been perfectly open to the court to say that, but the Court of Appeal said no, and so we have to take what they say seriously and listen. So I think the takeaways are that although there is no cap, the reasonable notice period is effectively a maximum of 24 months. Unless there are exceptional circumstances. But again, it's very unclear as to what constitutes exceptional, and if being 62 and having worked somewhere for 35 years isn't exceptional, I'm not sure what is. But anyway, it's very clear now, though, that employees' expectations regarding retirement at age 65 are not relevant considerations for notice period analysis. So, people who get to be 62 and 63 and are hoping to make it to 65, that may not help them on their notice period analysis. And lastly, even for employees with 30 plus years of service, it's going to be very difficult to obtain a notice period of more than 24 months. So, if you work somewhere for 24 years and a month per year analysis and what have you, that may make sense, but anything beyond that, you're going to be stuck at 24 months, it seems, based on the current state of case law. So, thank you. That's my presentation. Up next, Mr. Marty Rabinovich, and Marty's going to talk to you about the impact of technology on privacy issues in the workplace.
Thank you.